Rule 11. Inter- or intra-union disputes, and other related labor relations disputes. Section 1. Coverage. A. Inter- or intra-union disputes, shall include A. Conduct or nullification of election of officers of unions and workers' association. B. Audit or accounts examination of union or workers' association funds. C. Deregistration of collective bargaining agreements. D. Validity or invalidity of union affiliation or disaffiliation. E. Validity or invalidity of acceptance or non-acceptance for union membership. F. Validity or invalidity of voluntary recognition. G. Opposition to application for union or CBA registration. H. Violations of, or disagreements over any provision of the Constitution and bylaws of a union or workers' association. I. Disagreements over chartering, or registration of labor organization of the registration of collective bargaining agreements. J. Violations of the rights and conditions of membership in a union or workers' association. K. Violations of the rights of legitimate labor organizations, except interpretation of collective bargaining agreements. L. Validity or invalidity of impeachment or expulsion, or suspension, or any disciplinary action meted against any officer and member, including those arising from noncompliance with the repertorial requirements under Rule 5. M. Such other disputes or conflicts, involving the rights to self-organization, union membership and collective bargaining. 1. Between and among legitimate labor organizations, and 2. Between and among members of a union or workers' association. B. Other labor relations disputes, not otherwise covered by Article 217 of the Labor Code, shall include A. Any conflict between 1. A labor union and the employer, or 2. A labor union, and a group that is not a labor organization, or 3. A labor union, and an individual who is not a member of such union. B. Cancellation of registration of unions and workers' associations, filed by individual or individuals other than its members, or group that is not a labor organization, and C. A petition for interpleader involving labor relations. Section 2. Effects of the filing, or pendency of inter- or intra-union and other related labor relations disputes. The rights, relationships, and obligations of the parties litigants against each other and other parties in interest, prior to the institution of the petition, shall continue to remain during the pendency of the petition and until the date of finality of the decision rendered therein. Thereafter, the rights, relationships, and obligations of the parties litigants against each other and other parties in interest, shall be governed by the decision so ordered. The filing or pendency of any inter- or intra-union dispute, and other related labor relations dispute, is not a prejudicial question to any petition for certification of election, and shall not be a ground for the dismissal of a petition for certification election, or suspension of proceedings for certification election. Section 3. Who may file? Any legitimate labor organization, or member or members thereof specially concerned, may file a complaint or petition involving disputes or issues enumerated in Section 1 hereof. Any party in interest, may file a complaint or petition involving disputes or issues enumerated in Section 2 hereof. Where the issue involves the entire membership of the labor organization, the complaint or petition shall be supported by at least 30% of its members. Section 4. Where to file. Complaints or petitions involving labor unions with independent registrations, chartered locals, workers' associations, its officers or members shall be filed with the regional office that issued its certificate of registration, or certificate of creation of chartered local. Complaints involving federations, national unions, its officers or member organizations shall be filed with the Bureau. Petitions for cancellation of registration of labor unions with independent registration, chartered locals and workers' association, and petitions for deregistration of collective bargaining agreements, shall be resolved by the regional director. He or she may appoint a hearing officer from the Labor Relations Division. Other inter- or intra-union disputes and related labor relations disputes, shall be heard and resolved by the med arbiter in the regional office. Complaints or petitions involving federations, national or industry unions, trade union centers and their chartered locals, affiliates or member organizations, shall be filed either with the regional office or the Bureau. The complaint or petition shall be heard and resolved by the Bureau. When two or more petitions involving the same parties and the same causes of action are filed, the same shall be automatically consolidated. Section 5. Formal requirements of the complaint or petition. The complaint or petition shall be in writing, verified under oath and shall, among others, contain the following. A. Name, address and other personal circumstances of the complainant or complainants, or petitioner or petitioners. B. Name, address and other personal circumstances of the respondent or respondents, or persons charged. C. Nature of the complaint or petition. D. Facts and circumstances surrounding the complaint or petition. E. Cause or causes of action, or specific violations committed. F. A statement that the administrative remedies provided for in the Constitution and bylaws have been exhausted, or such remedies are not readily available to the complainant or complainants, or petitioner or petitioners, through no fault of his or her or their own, or compliance with such administrative remedies does not apply to complainant or complainants, or petitioner or petitioners. G. Relief or reliefs prayed for. H. Certificate of non-forum shopping, and I. Other relevant matters. Section 6. Raffle of the case. Upon the filing of the complaint or petition, the regional director, or any of his or her authorized representative in the regional office and the docket section of the Bureau, shall allow the party filing the complaint or petition, to determine the med arbiter or hearing officer assigned to the case by means of a raffle. Where there is only one med arbiter or hearing officer in the region, the raffle shall be dispensed with, and the complaint or petition shall be assigned to him or her. Section 7. Notice of preliminary conference. Immediately after the raffle of the case, or receipt of the complaint or petition, the same shall be transmitted to the med arbiter or hearing officer, as the case may be, who shall in the same instance prepare the notice for preliminary conference, and cause the service thereof upon the party filing the petition. The preliminary conference shall be scheduled within 10 days from receipt of the complaint or petition. Within 3 days from receipt of the complaint or petition, the med arbiter or hearing officer, as the case may be, shall cause the service of summons upon the respondent or respondents named therein, directing him or her to file his or her answer or comment on the complaint or petition, on or before the scheduled preliminary conference, and to appear before the med arbiter or hearing officer on the scheduled preliminary conference. Section 8. Conduct of preliminary conference. The med arbiter or hearing officer, as the case may be, shall conduct a preliminary conference and hearing, within 10 days from receipt of the complaint or petition. He or she shall exert every effort to effect an amicable settlement of the dispute. Where the parties agree to settle amicably, their agreements shall be specified in the minutes of the conference, and a decision based on compromise shall be issued by the med arbiter or regional director, as the case may be, within 5 days from the date of the mandatory conference. Where no amicable settlement is reached, the med arbiter or hearing officer, as the case may be, shall proceed with the stipulation of facts, limitation or definition of the issues, clarificatory questioning, and submission of laws and jurisprudence relied upon in support of each other's claims and defenses. Section 9. Conduct of hearing or hearings. The med arbiter or hearing officer, as the case may be, shall determine whether to call further hearing or hearings on the complaint or petition. Where the med arbiter or hearing officer, as the case may be, decides to conduct further hearing or hearings, he or she shall require the parties to submit the affidavits of their witnesses, and such documentary evidence material to prove each other's claims and defenses. The hearing or hearings shall be limited to clarificatory questions by the med arbiter or hearing officer, and must be completed within 25 days from the date of preliminary conference. The complaint or petition shall be considered submitted for decision after the date of the last hearing, or upon expiration of 25 days from date of preliminary conference, whichever comes first. Section 10. Affirmation of testimonial evidence. Any affidavit submitted by a party to prove his or her claims or defenses, shall be reaffirmed by the presentation of the affiant, before the med arbiter or hearing officer, as the case may be. Any affidavit submitted without the reaffirmation of the affiant during a scheduled hearing, shall not be admitted in evidence, except when the party against whom the affidavit is being offered admits all allegations therein, and waives the examination of the affiant. Section 11. Filing of pleadings. The parties may file his or her pleadings, including their respective position papers, within the 25-day period prescribed for the conduct of hearing or hearings. No other pleading shall be considered or entertained, after the case is considered submitted for decision. Section 12. Hearing and resolution of the complaint or petition in the Bureau. The Bureau shall observe the same process, and have the same period, within which to hear and resolve the complaints or petitions filed before it. Section 13. Decision. The Bureau and the med arbiter or regional director, as the case may be, shall have 20 days from the date of the last hearing, within which to decide the complaint or petition. The decision shall state the facts, findings, conclusion, and reliefs granted. Section 14. Release of decision. The notice of decision shall be signed by the records officer in the Bureau, and by the med arbiter or hearing officer in the regional office. Within 20 days from date of last hearing, the decision shall be released to the parties personally, on a date and time agreed upon during the last hearing. Section 15. Appeal. The decision of the med arbiter and regional director may be appealed to the Bureau by any of the parties within 10 days from receipt thereof, copy furnished the opposing party. The decision of the Bureau director in the exercise of his or her original jurisdiction may be appealed to the office of the Secretary by any party within the same period, copy furnished the opposing party. The appeal shall be verified under oath, and shall consist of a memorandum of appeal, specifically stating the grounds relied upon by the appellant, with supporting arguments and evidence. Section 16. Where to file appeal. The memorandum of appeal shall be filed in the regional office or bureau where the complaint or petition originated. Within 24 hours from receipt of the memorandum of appeal, the bureau or regional director shall cause the transmittal thereof, together with the entire records of the case, to the office of the Secretary or the Bureau, as the case may be. Section 17. Finality of decision. Where no appeal is filed within the 10-day period, the Bureau and Regional Director or Med Arbiter, as the case may be, shall enter the finality of the decision in the records of the case, and cause the immediate implementation thereof. Section 18. Period of reply. A reply to the appeal is filed by any party to the complaint or petition, within 10 days from receipt of the memorandum of appeal. The reply shall be filed directly with the Bureau or the Office of the Secretary, as the case may be. Section 19. Decision of the Bureau or Office of the Secretary. The Bureau Director or the Secretary, as the case may be, shall have 20 days from receipt of the entire records of the case, within which to decide the appeal. The filing of the Memorandum of Appeal from the decision of the Med Arbiter or Regional Director and Bureau Director, stays the implementation of the assailed decision. The Bureau or Office of the Secretary may call the parties to a clarificatory hearing, in aid of its appellate jurisdiction. Section 20. Finality of decision of Bureau or Office of the Secretary. The decision of the Bureau or the Office of the Secretary shall become final and executory after 10 days from receipt thereof by the parties, unless a motion for its reconsideration is filed by any party therein within the same period. Only one motion for reconsideration of the decision of the Bureau, or the Office of the Secretary in the exercise of their appellate jurisdiction, shall be allowed. Section 21. Execution of decision. The decision of the Med Arbiter and Regional Director shall automatically be stayed pending appeal with the Bureau. The decision of the Bureau in the exercise of its appellate jurisdiction shall be immediately executory upon issuance of entry of final judgment. The decision of the Bureau in the exercise of its original jurisdiction shall automatically be stayed pending appeal with the Office of the Secretary. The decision of the Office of the Secretary shall be immediately executory upon issuance of entry of final judgment. Section 22. Transmittal of records to the Regional Office or Bureau. Within 48 hours from notice of receipt of decision by the parties and finality of the decision, the entire records of the case shall be remanded to the Bureau or Regional Office of Origin for implementation. The implementation of the decision shall not be stayed, unless restrained by the appropriate court. Rule 12. Election of officers of labor unions and workers' associations. Section 1. Conduct of election of union officers. Procedure in the absence of provisions in the Constitution and bylaws. In the absence of any agreement among the members, or any provision in the Constitution and bylaws of a labor union or workers' association, the following guidelines may be adopted in the election of officers. A. Within 60 days before the expiration of the term of the incumbent officers, the President of the labor organization shall constitute a committee on election, to be composed of at least 3 members who are not running for any position in the election, provided that if there are identifiable parties within the labor organization, each party shall have equal representation in the committee. B. Upon constitution, the members shall elect the chairman of the committee from among themselves, and in case of disagreement, the President shall designate the chairman. C. Within 10 days from its constitution, the committee shall, among others, exercise the following powers and duties. 1. Set the date, time and venue of the election. 2. Prescribe the rules on the qualification and eligibility of candidates and voters. 3. Prepare and post the voters' list, and the list of qualified candidates. 4. Accredit the authorized representatives of the contending parties. 5. Supervise the actual conduct of the election, and canvass the votes to ensure the sanctity of the ballot. 6. Keep minutes of the proceedings. 7. Be the final arbiter of all election protests. 8. Proclaim the winners, and 9. Prescribe such other rules, as may facilitate the orderly conduct of election. Section 2. Dispute over conduct of election of officers. where the terms of the officers of a labor organization have expired, and its officers failed or neglected to do so, call for an election of new officers, or where the labor organization's constitution and bylaws do not provide for the manner by which the said election can be called or conducted, and the intervention of the department is necessary, at least 30% of the members of the labor organization may file a petition for the conduct of election of their officers, with a regional office that issued its certificate of registration, or certificate of creation if chartered local. In the case of federations, national or industry unions and trade union centers, the petition shall be filed with the Bureau or the regional office, but shall be heard and resolved by the Bureau. This rule shall also apply where a conduct of election of officers is an alternative relief, or necessary consequence of a petition for nullification of election of officers, impeachment or expulsion of officers, or such other petitions. Section 3. Formal Requirement and Proceedings. The formal requirements, processes and periods of disposition of this petition stated in Rule 11, shall be followed in the determination of the merits of the petition and appeal. Section 4. Pre-election conference and conduct of election. The appointment of an election officer, and the procedures and periods in the conduct of the pre-election conference, and election proceedings prescribed in Rule 9, shall also apply in the conduct of a pre-election conference, and election of officers in any labor organization. Section 5. Applicability of the provisions of the labor organization's constitution and bylaws. Where the conduct of election of officers is ordered by the Med Arbiter, the Bureau or Office of the Secretary, the rules and regulations governing the filing of candidacies and conduct of election, under the Constitution and bylaws of the labor organization may be applied in the implementation of the decision, or new and additional rules may be adopted, as agreed upon by the parties. The entire proceedings shall be presided by the election officer from the Labor Relations Division of the Regional Office, or the Bureau. He or she shall act as the COMLEC referred to in the labor organization's constitution and bylaws, and obligate himself or herself to comply with his or her mandate under the decision to be implemented, and the constitution and bylaws. Rule 13. Administration of trade union funds, and actions arising therefrom. Section 1. Right of union to collect dues and agency fees. The incumbent bargaining agent shall continue to be entitled to check off, and collect dues and agency fees, despite the pendency of a representation case, other inter- or intra-union disputes, or related labor relations disputes. Section 2. Visitorial power under Article 274. The regional or bureau director may inquire into the financial activities of any legitimate labor organization, and examine their books of accounts and other records, to determine compliance with the law and the organization's constitution and bylaws. Such examination shall be made upon the filing of a request, or complaint for the conduct of an accounts examination, by any member of the labor organization, supported by the written consent of at least 20% of its total membership. Section 3. Where to file. A request for examination of books of accounts of independent labor unions, chartered locals and workers' associations pursuant to Article 280, shall be filed with the regional office that issued its certificate of registration, or certificate of creation if chartered local. A request for examination of books of accounts of federations, or national unions and trade union centers, pursuant to Article 280, shall be filed with the Bureau. Such request or complaint, in the absence of allegations pertaining to a violation of Article 247, shall not be treated as an intra-union dispute, and the appointment of an audit examiner by the regional or bureau director, shall not be appealable. Section 4. Actions arising from Article 241. Any complaint or petition with allegations of mishandling, misappropriation or non-accounting of funds in violation of Article 247, shall be treated as an intra-union dispute. it shall be heard and resolved by the med arbiter pursuant to the provisions of Rule 21. Section 5. Prescription. The complaint or petition for audit or examination of funds and book of accounts, shall prescribe within 3 years from the date of submission of the annual financial report to the Department, or from the date the same should have been submitted as required by law, whichever comes earlier. Section 6. Decision. A decision granting the conduct of audit, shall include the appointment of the audit examiner, and a directive upon him or her to submit his or her report and recommendations within 10 days from termination of audit. The decision granting the conduct of audit is interlocutory, and shall not be appealable. The decision denying or dismissing the complaint or petition for audit, may be appealed within 10 days from receipt thereof, pursuant to the provisions prescribed in Rule 21. Section 7. Pre-audit conference. Within 24 hours from receipt of the decision granting the conduct of audit, the regional director shall summon the parties to a pre-audit conference conducted by the audit examiner, to determine and obtain the following. A. Sources of funds covered by the audit. B. The banks and financial institutions where the labor organization maintains its account. C. Union books of accounts and financial statements. D. Disbursement vouchers with supporting receipts, invoices and other documents. E. Income and revenue receipts. F. Cash books. G. Minutes of general membership meeting and board meetings. H. Other relevant matters and documents. The first pre-audit conference shall be scheduled within 10 days from receipt by the audit examiner of the decision granting the conduct of an audit. Section 8. Issuance of subpoena. The regional director may compel any party to appear, or bring the required financial documents in a conference or hearing, through the issuance of a subpoena ad testificandum or subpoena duces tecum. He or she may also require the employer concerned to issue certifications of union dues and other assessments remitted to the union during the period of audit. Section 9. Conduct of audit examination. Where book of accounts are submitted by the parties, the audit examiner shall A. Examine the transactions reflected in the disbursement vouchers. B. Determine the validity of the supporting documents attached to the vouchers, consistent with the union's constitution and bylaws, relevant resolutions of the union, and the labor code. C. Trace recording and posting in the disbursement book. D. Record observations or findings of all financial transactions. Where no book of accounts are maintained by the officers of the labor organization, the audit examiner shall A. Examine the transactions reflected in the disbursement vouchers. B. Determine the validity of the supporting documents attached to the vouchers, consistent with the labor organization's constitution and bylaws, relevant board resolutions, and the labor code. C. Prepare working papers or worksheet or worksheets. D. Record and post all financial transactions reflected in the cash vouchers in the working papers or worksheet or worksheets, and E. Record observations or findings of all financial transactions. The audit examiner shall conduct an inventory of all physical assets acquired by the labor organization, if any, and on the basis of his or her findings, prepare his or her audited financial report or statement reflecting the true and correct financial accounts and balances of the labor organization, with relevant annexes attached. Section 10. Period of audit. The audit examiner shall have 60 days from the date of first pre-audit conference, within which to complete the conduct of audit, unless the volume of financial records, the period covered by the audit, and other circumstances, warrant the extension thereof. In such a case, the audit examiner shall notify the med arbiter or the bureau director, as the case may be of such fact, at least 10 days before the expiration of the 60-day period. Section 11. Audit Report. The audit examiner shall make a report of his or her findings to the parties involved, and the same shall include the following. A. Name of the labor organization. B. Name of complainants or petitioners and respondents. C. Name of officers of the labor organization during the period covered by the audit report. D. Scope of the audit. E. List of documents examined. F. Audit methods and procedures adopted, and G. Findings and recommendations. Section 12. Completion of audit. A copy of the audit report shall be forwarded by the audit examiner to the med arbiter or the bureau director, as the case may be, within 10 days from termination of the audit, together with the entire records of the case and all documents relative to the conduct of the audit. Section 13. Decision after audit. The med arbiter or the bureau director shall render a decision within 20 days from receipt of the audit report. All issues raised by the parties during the conduct of the audit shall be resolved by the med arbiter. The decision shall be released in the same manner prescribed in Section 15, Rule 11. When warranted, the med arbiter or bureau director shall order the restitution of union funds by the responsible officer or officers in the same decision. Section 14. Appeal. Appeal from the decision of the med arbiter denying the conduct of audit and from the results of the audit, may be filed by any of the parties with the Bureau. Decisions rendered by the Bureau after the conduct of audit in the exercise of its original jurisdiction, may be appealed to the Office of the Secretary. Both shall be resolved in accordance with the provisions of Section 16, Rule 11. Section 15. Period of inquiry or examination. No complaint for inquiry or examination of the financial and book of accounts, as well as other records of any legitimate labor organization, shall be entertained during the 60-day freedom period, or within 30 days immediately preceding the date of election of union officers. Any complaint or petition so filed, shall be dismissed. Rule 14. Cancellation of registration of labor organizations. Section 1. Cancellation of registration. Where to file. Subject to the requirements of notice and due process, the registration of any legitimate independent labor union, local or chapter and workers' association, may be cancelled by the regional director, upon the filing of a petition for cancellation of union registration, or application by the organization itself for voluntary dissolution. The petition for cancellation or application for voluntary dissolution, shall be filed in the regional office which issued its certificate of registration or creation. In the case of federations, national or industry unions and trade union centers, the Bureau Director may cancel the registration, upon the filing of a petition for cancellation, or application for voluntary dissolution in the Bureau of Labor Relations. Section 2. Who may file? Any party in interest may commence a petition for cancellation of registration, except in actions involving violations of Article 24, which can only be commenced by members of the labor organization concerned. Section 3. Grounds for cancellation. Any of the following may constitute as grounds for cancellation of registration of labor organizations. A. Misrepresentation, false statement, or fraud in connection with the adoption or ratification of the Constitution and bylaws or amendments thereto, the minutes of ratification, the list of members who took part in the ratification. B. Misrepresentation, false statements, or fraud in connection with the election of officers, minutes of the election of officers, and the list of voters, or C. Voluntary dissolution by the members. Section 4. Voluntary cancellation of registration. How made? A legitimate labor organization may cancel its registration, provided at least 2/3 of its general membership votes to dissolve the organization in a meeting duly called for that purpose, and an application to cancel its registration is thereafter submitted by the board of the organization to the regional bureau director, as the case may be. The application shall be attested to by the president of the organization. Section 5. Action on the petition or application. The petition or application shall be acted upon by the regional or bureau director, as the case may be. In case of a petition for cancellation of registration, the formal requirements, processes and periods of disposition stated in Rule 11, shall be followed in the determination of the merits of the petition. Section 6. Prohibited grounds for cancellation of registration. The inclusion as union members of employees who are outside the bargaining unit, shall not be a ground to cancel the union registration. The ineligible employees are automatically deemed removed from the list of membership of the union. The affiliation of the rank and file, and supervisory unions operating within the same establishment to the same federation or national union, shall not be a ground to cancel the registration of either union. Rule 15. Registry of Labor Organizations and Collective Bargaining Agreements. Section 1. National Registry. The Bureau shall be the National Registry of Labor Organizations and Collective Bargaining Agreements, as such it shall A. Maintain a national registry. B. Within the month of March following the end of the calendar year, publish in the Department of Labor and Employment website, the list of labor organizations and federations, which have complied with the repertorial requirements of Rule 5, and delinquent labor organizations. C. Publish a list of officers of labor organizations, with criminal conviction by final judgment, and D. Verify the existence of a registered labor organization, with no registered collective bargaining agreement, and which has not been complying with the repertorial requirements for at least 5 years. The verification shall observe the following process. 1. The regional office shall make a report of the labor organization's noncompliance, and submit the same to the Bureau for verification. The Bureau shall send by registered mail with return card, to the labor organization concerned, a notice for compliance indicating the documents it failed to submit, and the corresponding period in which they were required, with notice to comply with the said repertorial requirements, and to submit proof thereof to the Bureau within 10 days from receipt thereof. Where no response is received by the Bureau within 30 days from the service of the first notice, it shall send another notice for compliance, with warning that failure on its part to comply with the repertorial requirements within the time specified, shall cause its publication as a non-existing labor organization in the DOLE website. 2. Where no response is received by the Bureau within 30 days from service of the second notice, the Bureau shall publish the notice of non-existence of the labor organization or organizations in the DOLE website. 3. Where no response is received by the Bureau within 30 days from date of publication, or where the Bureau has verified the dissolution of the labor organization, it shall delist the labor organization from the roster of legitimate labor organizations. Rule 16. Collective bargaining. Section 1. Policy. It is the policy of the state, to promote and emphasize the primacy of free and responsible exercise of the right to self-organization and collective bargaining, either through single enterprise level negotiations, or through the creation of a mechanism, by which different employers and recognized or certified labor unions in their establishments bargain collectively. Section 2. Disclosure of information. In collective bargaining, the parties shall, at the request of either of them, make available such up-to-date financial information on the economic situation of the undertaking, which is normally submitted to relevant government agencies, as is material and necessary for meaningful negotiations. Where the disclosure of some of this information could be prejudicial to the undertaking, its communication may be made condition upon a commitment that it would be regarded as confidential to the extent required. The information to be made available may be agreed upon between the parties to collective bargaining. Section 3. When single enterprise bargaining available. Any voluntarily recognized or certified labor union may demand negotiations with its employer for terms and conditions of work covering employees in the bargaining unit concerned. Section 4. Procedure in single enterprise bargaining. A recognized or certified labor union that desires to negotiate with its employer shall submit such intentions in writing to the employer, together with its proposals for collective bargaining. The recognized or certified labor union and its employer may adopt such procedures and processes they may deem appropriate and necessary for the early termination their negotiations. They shall name their respective representatives to the negotiation, schedule the number and frequency of meetings, and agree on wages, benefits and other terms and conditions of work for all employees covered in the bargaining unit. Section 5. When multi-employer bargaining available. A legitimate labor union or unions and employers may agree in writing to come together for the purpose of collective bargaining, provided a. Only legitimate labor unions who are incumbent exclusive bargaining agents may participate and negotiate in multi-employer bargaining. B. Only employers with counterpart legitimate labor unions who are incumbent bargaining agents may participate and negotiate in multi-employer bargaining, and C. Only those legitimate labor unions who pertain to employer units who consent to multi-employer bargaining may participate in multi-employer bargaining. Section 6. Procedure in multi-employer bargaining. Multi-employer bargaining may be initiated by the labor unions or by the employers. A. Legitimate labor unions, who desire to negotiate with their employers collectively, shall execute a written agreement among themselves, which shall contain the following. 1. The names of the labor unions, who desire to avail of multi-employer bargaining. 2. Each labor union in the employer unit. 3. The fact that each of the labor unions are the incumbent exclusive bargaining agents for their respective employer units. 4. The duration of the collective bargaining agreements, if any, entered into by each labor union with their respective employers. Legitimate labor unions who are members of the same registered federation, national, or industry union, are exempt from execution of this written agreement. B. The legitimate labor unions, who desire to bargain with multi-employers, shall send a written notice to this effect to each employer concerned. The written agreement stated in the preceding paragraph, or the certificates of registration of the federation, national, or industry union, shall accompany said notice. Employers who agree to group themselves, or use their existing associations to engage in multi-employer bargaining, shall send a written notice to each of their counterpart legitimate labor unions, indicating their desire to engage in multi-employer bargaining. Said notice shall indicate the following. 1. The names of the employers, who desire to avail of multi-employer bargaining. 2. Their corresponding legitimate labor organizations. 3. The fact that each corresponding legitimate union is any incumbent exclusive bargaining agent. 4. The duration of the current collective bargaining agreement, if any, entered into by each employer with a counterpart legitimate labor union. C. Each employer or concerned labor union shall express its willingness, or refusal to participate in multi-employer bargaining in writing, addressed to its corresponding exclusive bargaining agent or employer. Negotiations may commence only with regard to respective employers and labor unions, who consent to participate in multi-employer bargaining. D. During the course of negotiations, consenting employers and the corresponding legitimate labor unions shall discuss and agree on the following. 1. The manner by which negotiations shall proceed. 2. The scope and coverage of the negotiations and the agreement, and 3. Where appropriate, the effect of the negotiations on current agreements or conditions of employment among the parties. Section 7. Posting and registration of collective bargaining agreement. 2 signed copies of collective bargaining agreement, reached through multi-employer bargaining, shall be posted for at least 5 days in 2 conspicuous areas in workplace of the employer units concerned. Said collective bargaining agreement shall affect only those employees in the bargaining units who have ratified it. The same collective bargaining agreement shall be registered with the department in accordance with the following rule. Rule 17. Registration of collective bargaining agreements. Section 1. Where to file. Within 30 days from execution of a collective bargaining agreement, the parties thereto shall submit 2 duly signed copies of the agreement to the regional office which issued the certificate of registration, or certificate of creation of chartered local of the labor union, party to the agreement. Where the certificate of creation of the concerned chartered local was issued by the Bureau, the agreement shall be filed with the regional office which has jurisdiction over the place where it principally operates. Multi-employer collective bargaining agreement shall be filed with the Bureau. Section 2. Requirements for registration. The application for CBA registration shall be accompanied by the original and 2 duplicate copies of the following documents, which must be certified under oath by the representative or representatives of the employer, or employers and labor union or unions concerned. A. The collective bargaining agreement. B. A statement that the collective bargaining agreement was posted in at least 2 conspicuous places in the establishment, or establishments concerned for at least 5 days before its ratification, and C. A statement that the collective bargaining agreement was ratified by the majority of the employees in the bargaining unit of the employer or employers concerned. No other document shall be required in the registration of collective bargaining agreements. Section 3. Payment of registration fee. The certificate of registration of collective bargaining agreement shall be issued by the regional office upon payment of the prescribed registration fee. Section 4. Action on the application. The regional office and the Bureau shall act on applications for registration of collective bargaining agreements, within 1 day from receipt thereof, either by A. Approving the application, and issuing the certificate of registration, or B. Denying the application for failure of the applicant to comply with the requirements for registration. Where the documents supporting the application are not complete, or are not verified under oath, the regional office or the Bureau shall, within 1 day from receipt of the application, notify the applicants in writing of the requirements needed to complete the application. Where the applicants fail to complete the requirements within 10 days from receipt of notice, the application shall be denied without prejudice. Section 5. Denial of registration. Grounds for appeal. The denial of registration shall be in writing, stating in clear terms the reasons therefor, and served upon the applicant union and employer within 24 hours from issuance. The denial by the Regional Office of the Registration of Single Enterprise Collective Bargaining Agreements may be appealed to the Bureau within 10 days from receipt of the notice of denial. The denial by the Bureau of the Registration of Multi-Employer Collective Bargaining Agreements may be appealed to the Office of the Secretary within the same period. The Memorandum of Appeal shall be filed with the Regional Office or the Bureau, as the case may be. The same shall be transmitted, together with the entire records of the application, to the Bureau or the Office of the Secretary, as the case may be, within 24 hours from receipt of the Memorandum of Appeal. Section 6. Period and manner of disposition of appeal. The Bureau and the Office of the Secretary shall resolve the appeal within the same period and in the same manner prescribed in Rule 11 of these rules. Section 7. Term of representation status. Contract bar rule. The representation status of the incumbent exclusive bargaining agent, which is a party to a duly registered collective bargaining agreement, shall be for a term of 5 years from the date of the effectivity of the collective bargaining agreement. No petition, questioning the majority status of the incumbent exclusive bargaining agent, or petition for certification election, filed outside of the 60-day period immediately preceding the expiry date of such 5-year term, shall be entertained by the Department. The 5-year representation status acquired by an incumbent bargaining agent, either through single enterprise collective bargaining, or multi-employer bargaining, shall not be affected by a subsequent collective bargaining agreement, executed between the same bargaining agent and the employer during the same 5-year period. Section 8. Renegotiation of collective bargaining agreements. All provisions of a collective bargaining agreement, except the representation status of the incumbent bargaining agent shall, as a matter of right, be renegotiated not later than 3 years after its execution. The renegotiated collective bargaining agreement shall be ratified, and registered with the same regional office, where the preceding agreement was registered. The same requirements and procedure in the registration of collective bargaining agreements prescribed in the preceding rules, shall be applied. Rule 18. Central Registry of Labor Organizations, and Collective Bargaining Agreements. Section 1. Forms for registration. Consistent with the policy of the state to promote unionism, the Bureau shall devise or prescribe such forms as are necessary, to facilitate the process of registration of labor organizations and collective bargaining agreements, or of compliance with all documentary or reporting requirements prescribed in these rules. Section 2. Transmittal of records. Central Registry. The Labor Relations Division of the regional offices shall, within 48 hours from issuance of a Certificate of Creation of Chartered Locals, or Certificate of Registration of Labor Organizations and Collective Bargaining, transmit to the Bureau a copy of such certificates, accompanied by a copy of the documents supporting registration. The Labor Relations Division of the regional office shall also transmit to the Bureau a copy of every final decision, canceling or revoking the legitimate status of a labor organization or collective bargaining agreement, indicating therein the date when the decision became final. In cases of chartering and affiliation, or compliance with the reporting requirements under Rule 5, the regional office shall transmit within 2 days from receipt thereof, the original set of documents to the Bureau, retaining one set of documents for its file. Rule 19. Grievance machinery and voluntary arbitration. Section 1. Establishment of grievance machinery. The parties to a collective bargaining agreement shall establish a machinery for the expeditious resolution of grievances arising from the interpretation or implementation of the collective bargaining agreement, and those arising from the interpretation or enforcement of company personnel policies. Unresolved grievances will be referred to voluntary arbitration, and for this purpose, parties to a collective bargaining agreement shall name and designate in advance a voluntary arbitrator or panel of voluntary arbitrators, or include in the agreement a procedure for the selection of such voluntary arbitrator or panel of voluntary arbitrators, preferably from the listing of qualified voluntary arbitrators duly accredited by the board. In the absence of applicable provision in the collective bargaining agreement, a grievance committee shall be created within 10 days from signing of the collective bargaining agreement. The committee shall be composed of at least 2 representatives each from the members of the bargaining unit and the employer, unless otherwise agreed upon by the parties. The representatives from among the members of the bargaining unit shall be designated by the union. Section 2. Procedure in handling grievances. In the absence of a specific provision in the collective bargaining agreement, or existing company practice prescribing for the procedures in handling grievance, the following shall apply. A. An employee shall present his grievance or complaint orally, or in writing to the shop steward. Upon receipt thereof, the shop steward shall verify the facts and determine whether or not the grievance is valid. B. If the grievance is valid, the shop steward shall immediately bring the complaint to the employee's immediate supervisor. The shop steward, the employee and his immediate supervisor, shall exert efforts to settle the grievance at their level. C. If no settlement is reached, the grievance shall be referred to the grievance committee, which shall have 10 days to decide the case. Where the issue involves or arises from the interpretation or implementation of a provision in the collective bargaining agreement, or from any order, memorandum, circular or assignment issued by the appropriate authority in the establishment, and such issue cannot be resolved at the level of the shop steward or the supervisor, the same may be referred immediately to the grievance committee. Section 3. Submission to voluntary arbitration. Where grievance remains unresolved, either party may serve notice upon the other, of its decision to submit the issue to voluntary arbitration. The notice shall state the issue or issues to be arbitrated, copy thereof furnish the board, or the voluntary arbitrator or panel of voluntary arbitrators named or designated in the collective bargaining agreement. If the party upon whom the notice is served, fails or refuses to respond favorably within 7 days from receipt thereof, the voluntary arbitrator or panel of voluntary arbitrators designated in the collective bargaining agreement, shall commence voluntary arbitration proceedings. Where the collective bargaining agreement does not so designate, the board shall call the parties, and appoint a voluntary arbitrator or panel of voluntary arbitrators, who shall thereafter commence arbitration proceedings in accordance with the preceding paragraph. In instances where parties fail to select a voluntary arbitrator or panel of voluntary arbitrators, the regional branch of the board shall designate the voluntary arbitrator or panel of voluntary arbitrators, as may be necessary, which shall have the same force and effect, as if the parties have selected the arbitrator. Section 4. Jurisdiction of voluntary arbitrator or panel of voluntary arbitrators. The voluntary arbitrator or panel of voluntary arbitrators shall have exclusive and original jurisdiction to hear and decide all grievances arising from the implementation or interpretation of the collective bargaining agreements, and those arising from the interpretation or enforcement of company personnel policies, which remain unresolved after exhaustion of the grievance procedure. They shall also have exclusive and original jurisdiction to hear and decide wage distortion issues, arising from the application of any wage orders in organized establishments, as well as unresolved grievances, arising from the interpretation and implementation of the productivity incentive programs under RA No. 6971. The National Labor Relations Commission, its regional branches, and regional directors of the Department of Labor and Employment, shall not entertain disputes, grievances or matters under the exclusive and original jurisdiction of the voluntary arbitrator or panel of voluntary arbitrators, and shall immediately dispose and refer the same, to the appropriate grievance machinery or voluntary arbitration provided in the collective bargaining agreement. Upon agreement of the parties, any other labor dispute, may be submitted to a voluntary arbitrator or panel of voluntary arbitrators. Before, or at any stage of the compulsory arbitration process, the parties may opt to submit their dispute to voluntary arbitration. Section 5. Powers of voluntary arbitrator, or panel of voluntary arbitrators. The voluntary arbitrator or panel of voluntary arbitrators shall have the power to hold hearings, receive evidence, and take whatever action is necessary to resolve the issue or issues subject of the dispute. The voluntary arbitrator or panel of voluntary arbitrators may conciliate or mediate to aid the parties in reaching a voluntary settlement of the dispute. Section 6. Procedure. All parties to the dispute shall be entitled to attend the arbitration proceedings. The attendance of any third party, or the exclusion of any witness from the proceedings, shall be determined by the voluntary arbitrator or panel of voluntary arbitrators. Hearing may be adjourned for cause, or upon agreement by the parties. Unless the parties agree otherwise, it shall be mandatory for the voluntary arbitrator or panel of voluntary arbitrators to render an award or decision within 20 calendar days from the date of submission for resolution. Failure on the part of the voluntary arbitrator to render a decision, resolution, order or award within the prescribed period, shall, upon complaint of a party, be sufficient ground for the board to discipline said voluntary arbitrator, pursuant to the guidelines issued by the Secretary. In cases that the recommended sanction is listing, it shall be unlawful for the voluntary arbitrator to refuse, or fail to turn over to the board, for its disposition, the records of the case within 10 calendar days from demand thereof. Section 7. Finality of award or decision. The decision, order, resolution, or award of the voluntary arbitrator or panel of voluntary arbitrators, shall be final and executory after 10 calendar days from receipt of the copy of the award or decision by the parties, and it shall not be subject of a motion for reconsideration. Section 8. Execution of award or decision. Upon motion of any interested party, the voluntary arbitrator or panel of voluntary arbitrators, or the labor arbiter in the region where the movant resides, in case of the absence or incapacity for any reason of the voluntary arbitrator, or panel of voluntary arbitrators who issued the award or decision, may issue a writ of execution, requiring either the sheriff of the commission, or regular courts, or any public official whom the parties may designate in the submission agreement, to execute the final decision, order or award. Section 9. Cost of voluntary arbitration, and voluntary arbitrator's fee. The parties to a collective bargaining agreement, shall provide therein a proportionate sharing scheme, on the cost of voluntary arbitration, including the voluntary arbitrator's fee. The fixing of fee of voluntary arbitrators or panel of voluntary arbitrators, whether shouldered wholly by the parties, or subsidized by the Special Voluntary Arbitration Fund, shall take into account the following factors. A. Nature of the case. B. Time consumed in hearing the case. C. Professional standing of the voluntary arbitrator. D. Capacity to pay of the parties, and E. Fees provided for in the revised rules of court. Unless the parties agree otherwise, the cost of voluntary arbitration proceedings and voluntary arbitrator's fee, shall be shared equally by the parties. Parties are encouraged to set aside funds, to answer for the cost of voluntary arbitration proceedings, including voluntary arbitrator's fee. In the event the said funds, are not sufficient to cover such expenses, an amount by way of subsidy, taken out of the Special Voluntary Arbitration Fund, may be availed of by either or both parties, subject to the guidelines on voluntary arbitration to be issued by the Secretary. Section 10. Maintenance of case records by the Board. The Board shall maintain all records pertaining to a voluntary arbitration case. In all cases, the Board shall be furnished a copy of all pleadings, and submitted to the voluntary arbitrator, as well as the orders, awards and decisions issued by the voluntary arbitrator. The records of a case shall be turned over by the voluntary arbitrator or panel of voluntary arbitrators to the concerned regional branch of the board within 10 days upon satisfaction of the final arbitral award, order or decision. Rule 20. Labor Education and Research. Section 1. Labor Education of Workers and Employees. The Department shall develop, promote, and implement appropriate labor education and research programs on the rights and responsibilities of workers and employers. It shall be the duty of every legitimate labor organizations to implement a labor education program for its member, on their rights and obligations as unionist and as employees. Section 2. Mandatory conduct of seminars. Subject to the provisions of Article 247, it shall be mandatory for every legitimate labor organization to conduct seminars and similar activities on existing labor laws, collective agreements, company rules and regulations, and other relevant matters. The union seminars and similar activities may be conducted independently of, or in cooperation with the department and other labor education institutions. Section 3. Special Fund for Labor Education and Research. Every legitimate labor organization shall, for the above purpose, maintain a special fund for labor education and research. Existing strike funds may, in whole or in part, be transformed into labor education and research funds. The labor organization may also periodically assess and collect reasonable amounts from its members for such funds. Rule 21. Labor Management and Other Councils. Section 1. Creation of Labor Management and Other Councils. The Department shall promote the formation of labor management councils in organized and unorganized establishments, to enable the workers to participate in policy and decision-making processes in the establishment, insofar as said processes will directly affect their rights, benefits and welfare, except those which are covered by collective bargaining agreements, or are traditional areas of bargaining. The Department shall promote other labor management cooperation schemes and, upon its own initiative or upon the request of both parties, may assist in the formulation and development of programs and projects on productivity, occupational safety and health, improvement of quality of work life, product quality improvement, and other similar scheme. In line with the foregoing, the Department shall render, among others, the following services. A. Conduct awareness campaigns. B. Assist the parties in setting up labor management structures, functions and procedures. C. Provide process facilitators upon request of the parties, and D. Monitor the activities of labor management structures as may be necessary, and conduct studies on best practices, aimed at promoting harmonious labor management relations. Section 2. Selection of representatives. In organized establishments, the workers' representatives to the council shall be nominated by the exclusive bargaining representative. In establishments where no legitimate labor organization exists, the workers' representative shall be elected directly by the employees at large. Rule 22. Conciliation, strikes and lockouts. Section 1. Conciliation of labor management disputes. The board may, upon request of either of both parties, or upon its own initiative, provide conciliation mediation services to labor disputes other than notices of strikes or lockouts. Conciliation cases which are not subjects of notices of strike or lockout, shall be docketed as preventive mediation cases. Section 2. Privileged communication. Information and statements given in confidence at conciliation proceedings, shall be treated as privileged communications. Conciliators and similar officials, shall not testify in any court or body, regarding any matter taken up at conciliation proceedings conducted by them. Section 3. Issuance of subpoena. The Board shall have the power to require the appearance of any parties at conciliation meetings. Section 4. Compromise agreements. Any compromise settlement, including those involving labor standards laws, voluntarily agreed upon by the parties with the assistance of the Board and its regional branches, shall be final and binding upon the parties. The National Labor Relations Commission or any court, shall not assume jurisdiction over issues involved therein, except in case of noncompliance thereof, or if there is prima facie evidence, that the settlement was obtained through fraud, misrepresentation, or coercion. Upon motion of any interested party, the labor arbiter in the region where the agreement was reached, may issue a writ of execution, requiring a sheriff of the commission or the courts, to enforce the terms of the agreement. Section 5. Grounds for strike or lockout. A strike or lockout may be declared, in cases of bargaining deadlocks and unfair labor practices. Violations of collective bargaining agreements, except flagrant and malicious refusal to comply with its economic provisions, shall not be considered unfair labor practice, and shall not be strikeable. No strike or lockout may be declared, on grounds involving inter-union and intra-union disputes, or without first having filed a notice to strike or lockout, or without the necessary strike or lockout vote having been obtained, and reported to the Board. Neither will a strike be declared after assumption of jurisdiction by the Secretary, or after certification or submission of the dispute to compulsory or voluntary arbitration, or during the pendency of cases involving the same grounds for the strike or lockout. Section 6. Who may declare a strike or lockout? Any certified or duly recognized bargaining representative may declare a strike in cases of bargaining deadlocks and unfair labor practices. The employer may declare a lockout in the same cases. In the absence of a certified or duly recognized bargaining representative, any legitimate labor organization in the establishment may declare a strike, but only on grounds of unfair labor practices. Section 7. Notice of strike or lockout. In bargaining deadlocks, a notice of strike or lockout shall be filed with a regional branch of the Board, at least 30 days before the intended date thereof, a copy of said notice having been served on the other party concerned. In cases of unfair labor practice, the period of notice shall be 15 days. However, in case of unfair labor practice, involving the dismissal from employment of any union officer duly elected, in accordance with the union constitution and bylaws, which may constitute union busting, where the existence of the union is threatened, the 15-day cooling-off period shall not apply, and the union may take action immediately, after the strike vote is conducted and the results thereof submitted to the appropriate regional branch of the Board. Section 8. Contents of notice. The notice shall state, among others, the names and addresses of the employer and the union involved, the nature of the industry to which the employer belongs, the number of union members and of the workers in the bargaining unit, and such other relevant data as may facilitate the settlement of the dispute, such as a brief statement or enumeration of all pending labor disputes involving the same parties. In cases of bargaining deadlocks, the notice shall, as far as practicable, further state the unresolved issues in the bargaining negotiations, and be accompanied by the written proposals of the union, the counter-proposals of the employer, and the proof of a request for conference to settle the differences. In cases of unfair labor practices, the notice shall, as far as practicable, state the acts complained of, and the efforts taken to resolve the dispute amicably. In case a notice does not conform with the requirements of this and the foregoing section or sections, the regional branch of the Board shall inform the concerned party of such fact. Section 9. Action on notice. Upon receipt of the notice, the regional branch of the Board shall exert all efforts at mediation and conciliation, to enable the parties to settle the dispute amicably. The regional branch of the Board may, upon agreement of the parties, treat a notice, as a preventive mediation case. It shall also encourage the parties to submit the dispute to voluntary arbitration. During the proceedings, the parties shall not do any act which may disrupt or impede the early settlement of the dispute. They are obliged, as part of their duty, to bargain collectively in good faith, and to participate fully and promptly in the conciliation meetings called by the regional branch of the board. A notice, upon agreement of the parties, may be referred to alternative modes of dispute resolution, including voluntary arbitration. Section 10. Strike or lockout vote. A decision to declare a strike must be approved by a majority of the total union membership in the bargaining unit concerned, obtained by secret ballot in meetings or referenda called for the purpose. A decision to declare a lockout must be approved by a majority of the board of directors of the employer, corporation or association, or the partners in a partnership, obtained by a secret ballot in a meeting called for the purpose. The regional branch of the board may, at its own initiative or upon request of any affected party, supervise the conduct of the secret balloting. In every case, the union or the employer shall furnish the regional branch of the board, and the notice of meetings referred to in the preceding paragraph, at least 24 hours before such meetings, as well as the results of the voting at least 7 days before the intended strike or lockout, subject to the cooling off period provided in this rule. Section 11. Declaration of strike or lockout. Should the dispute remain unsettled, after the lapse of the requisite number of days from the filing of the notice of strike or lockout, and of the results of the election required in the preceding section, the labor union may strike, or the employer may lock out its workers. The regional branch of the board shall continue mediating and conciliating. Section 12. Improved offer balloting. In case of a strike, the regional branch of the board shall, at its own initiative or upon the request of any affected party, conduct a referendum, by secret balloting on the improved offer of the employer, on or before the 30th day of strike. When at least a majority of the union members vote to accept the improved offer, the striking workers shall immediately return to work, and the employer shall thereupon readmit them, upon the signing of the agreement. In case of a lockout, the regional branch of the board shall also conduct a referendum, by secret balloting on the reduced offer of the union, on or before 30th day of the lockout. When at least a majority of the board of directors or trustees, or the partners holding the controlling interest in the case of partnership, vote to accept the reduced offer, the workers shall immediately return to work, and the employer shall thereupon readmit them upon the signing of the agreement. Section 13. Peaceful picketing. Workers shall have the right to peaceful picketing. No person engaged in picketing shall commit any act of violence, coercion or intimidation, or obstruct the free ingress to, or egress from the employer's premises for lawful purposes, or obstruct public thoroughfares. No person shall obstruct, impede or interfere with, by force, violence, coercion, threats or intimidation, any peaceful picketing by workers during any labor controversy, or in the exercise of the right to self-organization or collective bargaining, or shall aid or abet such obstruction or interference. No employer shall use or employ any person to commit such acts, nor shall any person be employed for such purpose. Section 14. Injunctions. No court or entity shall enjoin any picketing, strike or lockout, except as provided in Articles 218 and 269 of the Labor Code. The Commission shall have the power to issue temporary restraining orders in such cases, but only after due notice and hearing, and in accordance with its rules. The reception of evidence for the application of a writ of injunction may be delegated by the Commission to any labor arbiter, who shall submit his recommendations to the Commission for its consideration and resolution. Any ex parte restraining order issued by the Commission, or its chairman or vice chairman where the Commission is not in session, and as prescribed by its rules, shall be valid for a period not exceeding 20 days. Section 15. Assumption by the Secretary of Labor and Employment. When a labor dispute causes, or is likely to cause a strike or lockout in an industry indispensable to the national interest, the Secretary of Labor and Employment may assume jurisdiction over the dispute and decide it, or certify the same to the National Labor Relations Commission for compulsory arbitration, provided that any of the following conditions is present. 1. Both parties have requested the Secretary of Labor and Employment to assume jurisdiction over the labor dispute, or 2. After a conference called by the Office of the Secretary of Labor and Employment on the propriety of its issuance, motu proprio, or upon a request or petition by either parties to the labor dispute. Such assumption shall have the effect of automatically enjoining an impending strike or lockout. If a strike or lockout has already taken place at the time of assumption, all striking or locked out employees and other employees subject of the notice of strike, shall immediately return to work, and the employer shall immediately resume operations and readmit all employees, under the same terms and conditions prevailing before the strike or lockout. Notwithstanding the foregoing, parties to the case may agree at any time, to submit the dispute to the Secretary of Labor or his duly authorized representative as voluntary arbitrator, or to a duly accredited voluntary arbitrator or to a panel of voluntary arbitrators. Section 16. Requirement for minimum operational service. In labor disputes adversely affecting the continued operation of hospitals, clinics or medical institutions, it shall be the duty of the striking union or locking out employer, to provide and maintain an effective skeletal workforce of medical and other health personnel, whose movement and services shall be unhampered and unrestricted, as are necessary to ensure the proper and adequate protection of the life and health of its patients, most especially emergency cases, for the duration of the strike or lockout. Section 17. Decision on the assumed labor dispute, finality. The decision of the Secretary of Labor and Employment, the NLRC, or voluntary arbitrator or panel of voluntary arbitrators, shall be rendered within 30 calendar days from submission of the case for resolution, and shall be final and executory 10 calendar days after receipt thereof by the parties. Section 18. Prohibitions on law enforcement agencies or public officials or employees, armed persons, private security guards and similar personnel in the private security agency, exception. No public official or employee, including officers and personnel of the Armed Forces of the Philippines, or the Philippine National Police, or armed person, private security guards and similar personnel in the private security agency, shall bring in, introduce or escort in any manner, any individual who seeks to replace strikers, in entering or leaving the premises of a strike area, or working place of the strikers. The police force shall keep out of the picket lines, unless actual violence, or other criminal acts occur therein. But any public officer, the Secretary of Labor and Employment, or the NLRC, may seek the assistance of law enforcement agencies, to maintain peace and order, protect life and property, and or enforce the law and legal order pursuant to the provisions of the Joint Dole-DILG-PASA guidelines in the conduct of PNP personnel, economic zone police and security guards, company security guards and similar personnel during labor disputes. Section 19. Criminal prosecution. The regular courts shall have jurisdiction over any criminal action under Article 278 of the Labor Code, as amended, but subject to the required clearance from the DOLE, on cases arising out of, or related to a labor dispute pursuant to the Ministry of Justice, now the Department of Justice, Circular No. 15, Series of 1982, and Circular No. 9, Series of 1986. Rule 23. Contempt. Section 1. Direct contempt, person guilty of misbehavior. A person guilty of misbehavior in the presence of, or so near the Secretary, the Chairman, or any member of the Commission, Bureau Director, or any labor arbiter, as to obstruct or interrupt the proceedings before the same, including disrespect toward said officials, offensive personalities toward others, or refusal to be sworn, or to answer as a witness, or to subscribe an affidavit, or deposition when lawfully required to do so, may be summarily adjudged in direct contempt by said officials, and punished by fines not exceeding 500 pesos, or imprisonment not exceeding 5 days or both, if it be the Secretary, the Commission or members thereof. Or fine not exceeding 100 pesos, or imprisonment not exceeding 1 day, or both, if it be the Bureau Director or Labor Arbiter. The person adjudged in direct contempt by a Labor Arbiter, may appeal to the Commission. While the person adjudged in direct contempt by the Bureau Director, may appeal to the Secretary. The execution of the judgment, shall be suspended, pending the resolution of the appeal upon the filing by such person of a bond, on condition that he will abide by, and perform the judgment should the appeal be decided against him. The judgment of the Commission and the Secretary, is immediately executory and unappealable. Section 2. Indirect contempt. Indirect contempt, shall be dealt with by the Secretary, Commission, Bureau Director, or Labor Arbiter, in the manner prescribed under Rule 71 of the Revised Rules of Court. Rule 24. Execution of decisions, awards or orders. Section 1. Execution of decisions, orders or awards. A. The Secretary, or the Bureau, or Regional Director, the Labor Arbiter, the Med Arbiter or Voluntary Arbitrator may, upon his or her own initiative, or on motion of any interested party, issue a writ of execution on a judgment, within 5 years from the date it becomes final and executory, requiring the sheriff or the duly deputized officer to execute or enforce their respective final decisions, orders and awards. B. The Secretary and the Chairman of the Commission, may designate special sheriffs, and take any measure under existing laws, to ensure compliance with their decisions, orders or awards, and those to the labor arbiters and voluntary arbitrators, including the imposition of administrative fines, which shall not be less than 500 pesos nor more than 10,000 pesos. C. Alternatively, the Secretary of the Commission, any labor arbiter, the Regional Director, or the Director of the Bureau of Labor Relations, in appropriate cases, may deputize the Philippine National Police or any law enforcement agencies in the enforcement of final awards, orders or decisions. Rule 25. General Provisions. Section 1. Incidental motions will not be given due course. In all proceedings at all levels, motions for dismissals, or any other incidental motions, shall not be given due course, but shall remain as part of the records, for whatever they may be worth when the case is decided on the merits. Section 2. Non-intervention of outsiders in labor disputes. No person other than the interested parties, their counsels, or representatives, may intervene in labor disputes pending before the regional office, the Bureau, labor arbiters, the compulsory or voluntary arbitrators, the Commission, and the Secretary. Any violation of this provision, will subject the outsider to the administrative fines and penalties provided for in the Code. Section 3. When complaint deemed filed. A complaint is deemed filed, upon receipt thereof by the appropriate agency which has jurisdiction over the subject matter and over the parties. Section 4. Checkoff from non-members. Pursuant to Article 254E of the Code, the employer shall check off from non-union members, within a collective bargaining unit, the same reasonable fee equivalent to the dues and other fees normally paid by union members, without the need for individual checkoff authorizations. Rule 26. Transitory Provisions. Section 1. Rules governing prior applications, petitions, complaints, cases. All applications, petitions, complaints, cases or incidents commenced or filed prior to the effectivity of these amendatory rules, shall be governed by the old rules, as amended by Department Order No. 9, Series of 1997. Section 2. Equity of the incumbent. Industry unions, or trade union centers registered by virtue of the old rules, as amended by Department Order No. 9, Series of 1997, shall maintain their legitimate status, with all rights and obligations appurtenant thereto.